Association of Women Judges. It was this fall and held in Bemidji. Part of the conference was a mock trial put on by local high school students, and Ms. Morley and I were both assigned to mentor kids playing parts for the defense, and we sat behind them at the trial, and I'm not sure who was more excited and having more fun during that trial, if it was the kids or if it was the mentors. So we were definitely cheering them on during the whole thing. And when Ms. Morley was assigned to the defense, it was pointed out to the kids and everyone else there that that this was done on purpose, that she was put on the defense side on purpose because she is a prosecutor by trade. It wasn't until this event came up that I truly appreciated what this meant. And as you can read from her bio, she has had an extensive career as a prosecutor, adjudicating crimes arising especially in Indian country. She has had an extensive career working in Indian country. So 3 years helping, she worked 3 years helping revise the tribal code for the Turtle Mountain Band of Chippewa. She worked 2 years as the chief judge for the Turtle Mountain tribe. And then in 1998, she became an assistant U.S. State attorney in Fargo. In that capacity, she continued her work for tribes, serving 18 months with the Executive Office of the U.S. Attorneys, specifically working with Native American Issues Subcommittee on Civil Rights Subcommittee for the Attorney General Counsel. Currently, she is the tribal liaison for the U.S. State's Attorney's Office, which prosecutes federal crimes arising on the Spirit Lake Reservation. In this capacity, Ms. Morley went before the 8th Circuit Court of Appeals in the U.S. v. Cavanaugh, and it's on this case that she is here to speak with us today. And so I would like you to help me joining in welcoming her today. Thank you.
Thank you. I want to say first and foremost, this is the first opportunity I've had to come back to the campus of the University of North Dakota, home of the North Dakota students. I am and always will be in my heart a proud alumni of the University of North Dakota, whatever our team name turns out to be. This is a great university. Those of you who are students in the audience, I can't tell you how proud I am to be able to say that the University of North Dakota School of Law has one of the finest Indian law programs that I have ever had the privilege of being a part of. And I consider that I'm a part of it today because I get to talk to you about a case that has implications to Native Americans on Indian reservations all over the United States. And I'm talking about the Cavanaugh case. At the time that I got this case, did I think it would ever hold such significance? No. You never see them when they come in the door. They don't come wrapped up in bright, shiny wrappers and say, look at me, I'm going to take you all the way to the doors of the Supreme Court. And this one didn't. It looked to me like another case where a man had beat up his wife severely on the Indian reservation, and we now had a new tool, and we say we carry a little briefcase of tools. And in our tools, there was this new law that now allowed tribal court convictions to be elevated to a federal felony. And you have to recall that tribal court convictions are only misdemeanors. They have no felony jurisdiction in tribal courts. And so I looked at this case and I'm like looking over all the elements that I need to prove. And one of the things that I need to prove, I brought along the actual the actual federal statute that talks about what the elements of the offense are for the recidivist, I have a hard time with some words, repeat offenders in domestic violence. And I needed to prove that there was an action of domestic violence that occurred on an Indian reservation, and I needed to prove that there had been 2 prior convictions that are called predicate offenses, And these predicate offenses then elevated, even though it was a misdemeanor assault against Roman Cavanaugh's girlfriend, that I could bring this to a felony level and bring it into federal court and prosecute him. So the first thing I did was I ordered the transcripts and I ordered the certified copies of the convictions in tribal court. And I didn't just have 2 predicate offenses, I had actually 3 prior convictions on Roman Cavanaugh. One of the convictions, before he had even had an opportunity to make his appearance in tribal court, he offended her again and assaulted her again and had a second charge against her. So when he went to court, he pleaded guilty and we had 1 judgment, but it had 2 separate instances of domestic abuse against Roman Cavanaugh's girlfriend. Mother of his children, they have 4 children together. One of the things that happened when they sent these certified copies of these offenses is I sent out an email, and we have what's called nationwides. I work for the U.S. Attorney's Office, and other assistant U.S. attorneys that work in Indian country, we have our own little chain that strings us all together, and you send one out and you say, hey, I need some help. And I was like, hey, has anyone ever had the issue of what exactly these predicate offenses have to have in them? I mean, the statute reads that it could be a state conviction, it could be a federal conviction, or it could be a tribal conviction in order to have the enhanced penalty of a federal felony. Nobody had ever had that question presented to them, and the ones who did respond back to me had court-appointed counsel, had law-trained judges, and had law-trained prosecutors in their system, primarily Don Gast out of North Carolina working with the Cherokee Nation. And I'm like, has anybody had any uncounseled predicate convictions? And nobody had had that question presented to them. So, loving to blaze new ground, I filed it against Roman, and what happened was he got the court-appointed public defenders. But Roman decided that the court-appointed public defenders had a conflict with him, and he asked the court to appoint him new counsel. And when the court appointed him new counsel, and if this is being recorded, and Alex, you hear me say this, lo and behold, one of the greatest attorneys in the state of North Dakota that loves to take on new ground and challenge the authority of the federal government in Indian country, Alex Reichert, got appointed to defend Mr. Cavanaugh. And I expected, and I sent a plea agreement to Alex, and I expected Alex to call me back and argue terms. I don't think he should have to serve this much time, and I think that we can agree that this, and instead I get a motion to dismiss based on the fact that it was a violation of Roman Cavanaugh's Sixth Amendment right to counsel. I'm like, I picked up the phone and I'm like, Alex, is this for real? And he goes, I think this is going to take me back to the Supreme Court, Jan. Alex and I had been to the Supreme Court on Billy Joe Laura, and he's always looking for the next case that was left open. And he didn't win with the Supreme Court on Laura, and he said, this is the one I've been waiting for. I think I'm going to get back, Jan. So he filed his brief in support of his motion. I responded, and then we had arguments in front of Judge Erickson. And Alex was relying very heavily on this Ninth Circuit case, and it's called Ant. Now, any of you that have watched the Supreme Court know that the Ninth Circuit always gets overturned for one case or another in front of the Supreme Court every term. Now, when I was doing Laura, I was standing with my fingers crossed because I was relying on a Ninth Circuit case, and I just kept waiting for some other case to come up where they were going to overturn the Ninth, and mine would be upheld. So Alex is relying on this Ant case. And wow, I read the Ant case, and I read Alex's brief, and I thought, I'm dead in the water. And I tried to overcome Ant by claiming the distinction. In Ant, what it was is the state of Montana was going to take a tribal court conviction for DUI, and they were going to use that DUI conviction and say, now we have an enhanced penalty in the state. And our enhanced penalty says anytime that you have whatever, I don't know if it was 3 predicate DUIs, you get an enhanced penalty, which is exactly what we were saying in Cavanaugh. We were saying anytime you have these prior convictions, then on the 3rd one, we get to give you the enhanced penalty of a felony. However, I was trying to make Ant and distinguish Ant, and I argued back, and I said, look, I said, they're taking an actual conviction in tribal court, and they're saying that because he was convicted in tribal court, we can just take that guilty plea and we can bring it in to the federal court and say, we win, he pled there so he can plead here. It's the same offense. We're not doing that in Cavanaugh. In Cavanaugh, we're saying he's had these previous convictions and the law requires us to show that he had these previous convictions, but this offense is the one that the jury is going to decide, was this domestic abuse and did he have the predicate offenses? All I would be doing is introducing him. Alex said he didn't have counsel, and that argument persuaded Judge Erickson, and Judge Erickson dismissed my indictment. And Roman Cavanaugh was set free that day. However, I went back downstairs and we talked it over, and in order for when we lose, we have to appeal to Washington, D.C., and when I say appeal, I'm not talking about writing out appeals. I'm saying we get on the telephone and we talk to Washington, D.C., and we say, I don't necessarily agree with what just happened in court today. Can we appeal this decision? We can't just do it of our own right. So we get on the phone and we start talking to Washington about the significance of this case. And then I've got the Violence Against Women office on the phone, and I've got the Civil Rights on the phone, and I've got our appellate division on the phone, and I'm saying, don't appeal. And they're like, what do you mean don't appeal? And I'm like, you know what, here's my fear. I don't have a real good set of fact pattern here because the Spirit Lake Tribal Court does not have law-trained judges. They do not have court-appointed counsel that are attorneys, and they don't have the public defender system of lawyers. I said, I'm afraid that if they strike this law down, no one's going to get to use it. But under the right set of facts, as Don Gass told me, it's working very well in North Carolina. And as I heard down in South Dakota, there were some tribal courts that were practicing down in South Dakota, and they had court-appointed counsel in their court system. And I was afraid. I was fearful that they were going to strike it down and then no one would get to use this. And this was a good law. This was a very, very good law. However, I wish I had a flag, I'd raise it right now. My client is the United States of America. Wave the flag. And my client, by right, is the Congress of the United States. And when they pass a law, presumptively, they have already had that law vetted, and anything that the Congress of the United States does is presumptively valid until the United States Supreme Court tells them. So, I mean, I wasn't the one to be saying, no, we're not going to appeal this. So we did appeal it. And when we argued in front of the Eighth Circuit, we were talking about the things that, hey, in this tribal court, they followed the tribal court laws when Roman Cavanaugh went to court. They read him what the violation was. They read him his rights, and we had all of those documents that had shown that Roman Cavanaugh had the opportunities in tribal court, and that Roman Cavanaugh validly waived those rights. He signed a piece of paper, we showed that. But the one thing that they had gotten hung up about was this constitutional right. And I was like, well, you know what? Under the Indian Civil Rights Act, the Spirit Lake law is still valid, and the conviction is still valid. And the reason it was valid is because tribes predate the Constitution. And the Indian Civil Rights Act that was passed, Section 1302, title, let's see, It's in the U.S. Code at Title 25 and it's Section 1302. And when you look at that, it is the Indian Civil Rights Act that talks about all the things that tribes must guarantee. And the Indian Civil Rights Act guarantees the right to the right to counsel in tribal court proceedings. What it doesn't guarantee is that the tribe will pay for that counsel. You can have counsel present, but you have to pay for it. And Roman Cavanaugh was advised that he could have legal counsel present. What he wasn't provided was court-appointed counsel at the expense of the tribe. But that wasn't a violation of the Constitution, Sixth Amendment rights in tribal court because it didn't apply to the tribe. And that was our argument. The tribal court conviction was validly entered under the tribal laws, under the Indian Civil Rights Act, and it wasn't a violation of the Constitution. And when the Eighth Circuit rendered their opinion, I want to give you a little background history. When Roman Cavanaugh assaulted his wife, he assaulted his wife at 2 o'clock in the morning in a vehicle, and he was intoxicated and she was intoxicated, and they had 3 of their children in the vehicle. And he would be driving the vehicle, and he grabbed her by her head, and he banged her into the dash, and then he brought his knee up, and he was actually kneeing her in the forehead. And she was trying to push him away. When she tried to push him away, he bit into her hand, and he actually took a chunk of the webbing between your thumb and your forefinger out. He bit that out on her. She managed to get out of the vehicle and ran across a field. He drove the vehicle in there. He couldn't find her, and then he finally drove home. Now, any other person beats a federal indictment by getting it dismissed. Don't you walk on eggshells until you find out that that appeal has been confirmed and you're not subject to prosecution. Not Roman Cavanaugh. When I was talking on the telephone and talking with DC, I said, you know what? Roman Cavanaugh is the poster child. He is the poster child of why this law was even enacted. Because after this case was dismissed, Roman Cavanaugh assaulted 3 of his 4 children, actually 5. And one of the younger children ran next door to a neighbor's house and had red marks that later turned to a bruise on his face and said, "Call the police, call the police. My dad is killing my brother." And Roman at that time, when the young boy had ran out, had the oldest one of his children down and was literally choking him to the extent that the little boy couldn't speak. His lips swelled up to the top lip touching the nose and the bottom lip touching his chin. And then he had red marks from where his dad had actually slammed him into a wall and then was holding him down and choking him. So we prosecuted Roman for that one under felony child abuse. So when I'm making my arguments and I'm saying, you know, don't appeal this, I'm not saying don't appeal this because Roman Cavanaugh is innocent and not worthy of a prosecution. I'm saying this because I'm afraid that we're going to lose the ability to prosecute these offenses. And I'm aware that the Tribal Law and Order Act is at some point being discussed, and possibly, you know, we're going to start seeing some changes within the tribal courts. I'm glad. I'm very, very glad that the decision to appeal the case happened, and when the Eighth Circuit was looking at the questions of court-appointed counsel, they gave credence to the fact that we said, look, this conviction, these 2 convictions of Mr. Cavanaugh that happened in tribal court were validly obtained. And reading the decision and reading it again today, looking at some of the language that the court went through in coming to the decision that the Sixth Amendment right to counsel doesn't apply to tribes. You see some of the movements. You ever hear how, you know, the law has, it's tortured, and especially when you get to Indian law, it's fractured, and how it will be contorted in order to find the happy place to get to the answer that they want to come to. Well, they made a lot of steps because they looked at United States Supreme Court decisions, how they were arrived at, and yet they still came back to the same thing. We can't tell tribal courts what their laws will be. That's what the Eighth Circuit was talking about. We look at these laws and how these laws apply to the federal courts. And then you got to read Judge Bai's dissent, because Judge Bai gets to the very way that I was feeling with this queasiness in the bottom of my stomach when I'm saying, you know, yes, the Constitution doesn't apply to the tribes, but the Constitution applies to me. And the Constitution applies to every person who walks into the federal court. And when they walk into the federal court, they walk into the federal court cloaked with all of the rights of the Constitution. And here we were prosecuting Roman Cavanaugh and saying, all those rights from the Constitution apply when you come into federal court, but they don't apply to you when you're in the tribal court. And that is how the case ended up being decided. The Constitution and the rights of counsel, even though you're in the federal court, they're not going to look behind the validity of the tribal court convictions. If those tribal court convictions were obtained according to the tribal law and according to the Indian Civil Rights Act, and they're valid convictions, the Eighth Circuit said that the district court had no right to go behind and try to decide these cases and to confer rights onto Mr. Cavanaugh that the tribe did not have the ability or chose not to give to Mr. Cavanaugh at the time that these convictions came about. Mr. Cavanaugh then pled guilty. The Eighth Circuit reversed the district court, and they reinstated the indictment, and then Mr. Cavanaugh pleaded guilty. And when Mr. Cavanaugh pleaded guilty, then he had to be sentenced. But of course, Mr. Cavanaugh would have pleaded guilty at the very beginning. He wouldn't have had the second subsequent felony that he got for abusing his children. So on the abuse of his children, he got a sentence of 55 months and 3 years of supervised release after he's released from serving that sentence. On the assault against his spouse, I always think about Saturday Night Live when they say spousal unit, because that, you know, that really describes it. They weren't married, but they were in a relationship and lived together as man and wife, and they had children together. So his spousal unit, when he assaulted her, he got a sentence of 66 months and 3 years of supervised release. And he got that sentence consecutive to the sentence that he was already serving. And interestingly, very, very interestingly, these are the things that are not reported in any of the law books that you have here. But at sentencing, Roman Cavanaugh, Mr. Brutal Roman Cavanaugh, who assaulted 3 of his children and who assaulted his spousal unit numerous times, stood up and begged for mercy not to have to go to a federal prison because they would pick on him there. And I just thought that was just the epitome. I mean, they always get a right to address the court, and I thought that was just the epitome of what happens to bullies. I mean, you see it all the time in schoolyards, when, what is that one favorite show of mine at Christmas time about the little boy who's all dressed up in the Christmas Story, gosh. And the bully, when he'll shoot your eye out. And when the bully actually gets beat up and he cries, and it was so fitting to see Roman Cavanaugh standing up and pleading and basically saying, you know, they'll shoot my eye out if I go to a federal prison. He was afraid. I always feel good that I can put things back on track because I'm supposed to leave some time for questions, and we can get this back to 2:35 with your questions.
Yes. What is the impact of the Cavanaugh decision on the federal government's influence to tribal sovereignty?
What is the effect of the Cavanaugh decision on tribal sovereignty and the federal government's relationship with tribal sovereignty? Is that it? Actually, I think the Cavanaugh decision upholds the tribal sovereignty. I think it's an opinion that is very significant in saying, tribal courts, you have the authority and sovereignty. I'm going to get this right. Sovereignty is the right to be governed by the laws of your own nation, and that's what a sovereign is. So the federal government is looking and they're saying, we recognize that we have these rights in the federal government, but we're looking at what rights you have as a sovereign, and you have the ability to give him court-appointed counsel if that's your choice. We're not going to impose that and say it's invalid because you didn't give him court-appointed counsel. So I think it's a good decision.
Curious, Jen, about the predicate offenses that you talked about. They could be misdemeanor predicate offenses as well to enhance in the federal system. It has to be a felony level offense, though, in the federal system that you're enhancing?
It does. What the recidivist repeat domestic violence offender statute says is that with two predicate offenses, it rises to a federal felony with a maximum penalty of 10 years of imprisonment. We still follow the advisory guidelines when we look at what the sentence will be. As far as our federal code, Title 18, 1153 section is all entitled Indians, and they have, at 1153, they have a section that's listed as the major crimes. And in order for us to have felony jurisdiction, it has to be one of the major crimes. And this isn't based on the 1153 jurisdiction. However, we do look at what our jurisdictions are on the reservation. He's had his bite at the apple in tribal court. And when you look at what the rationale, look at the legislative history of why they enacted the repeat domestic violence offenders, you have people that are beating their wives, but they're not beating them to the level of one of our major crimes. And our major crimes would require an assault with a deadly weapon, an assault resulting in serious bodily injury, assault with the intent to commit murder or murder. And it's not rising to that level, but it's constant. And the tribal courts have said, look, what do you do about this guy that constantly beats his wife? He gives her the black eye, he gives her the broken arm. Broken arm we could probably take, but it's usually not one of those serious bodily injury that we have to meet by definition. And so, no, we don't do a misdemeanor jurisdiction offense on it. And tribal courts, until the Tribal Law and Order Act was enacted, only had misdemeanor jurisdiction. Long answer, no.
I was just wondering, in your practice, how often do you see this statute being utilized to convict perpetrators in Indian country?
In Indian country, after the Cavanaugh decision, and you have to know there's always companion cases, right? At the same time that Cavanaugh was being decided, down in Utah, they had Cavanaugh. And so Cavanaugh and Cavanaugh were decided within 1 week of each other. And of course, defense attorneys and the internet explode with, this worked, I got a dismissal. So Cavanaugh did the same thing and got a dismissal. And then within, I believe that Cavanaugh was decided in July, and Cavanaugh was decided in August. They were very, very close in their decisions, and they both affirmed the federal government's use of it. And following that, we had, especially in the 8th, we had it on hold because the district court had struck it down as unconstitutional, so no one was going to bring it up. And I've seen it used 4 times since then.
What do you think the impact would have been if Cavanaugh were not decided the way that it was?
The impact of this not being decided in favor of the United States would have been, as I had feared. I said that I was against the appeal initially. Of course, I was 100% behind it once the government told us, or the department told us that we would appeal. I think it would have been that women on Indian reservations who are married to tribal members or non-tribal members were going to walk around with black eyes, we're going to walk around with puffy cheeks, big lips, and there wouldn't be any recourse other than looking to your own tribal governments and saying you need to do something to protect us. And we know that the Tribal Law and Order Act, that the Indian Affairs Commission of the United States Senate went out and actually took testimony and said, we want to hear what's wrong with the, and I don't want to say the judicial system, but I want to say the safety, because the numbers were reported. There was an article that came out, and it was from Amnesty International. And Amnesty International, whether I agree with the article or not, has been accepted as fact in Indian country that Native American women are 2.5 times more likely to be the victims of domestic assault and rape, and that 1 in 3 women in Indian country is going to experience an incident of domestic assault or rape in her lifetime. After that, the Tribal Law and Order Act got enacted. So I think the decision that came out in Cavanaugh really went hand in hand with what happened nationally when people started saying, hey, you know what, it isn't right that Indian women can't be protected in their own environment. And as Roman was the poster child for why we needed to have laws like this, I think that it was a good decision. And I think that the flip side of that would be that women wouldn't be protected as well in Indian country because we only have limited federal jurisdiction. And we don't have jurisdiction over the misdemeanor acts that Roman was committing on his spousal unit.
You say there were other circuits deciding that. Have you, or within a week out of Utah, are you aware of like other circuits that have come out on the same issue, maybe opposite, besides the Ninth Circuit DUI case you were talking about? You
know, I have heard that there's a case percolating in Montana that could possibly give us our split. When Cavanaugh came back and was decided, and I believe Cavanaugh was out of the Second Circuit, what Cavanaugh was relying on was a Ninth Circuit case of Ant, and the Eighth Circuit did a wonderful job of, I believe it was Malloy who wrote for the court in the Cavanaugh decision, and did a wonderful job of distinguishing that, yes, Ant was out of the same offense, and Ant was trying to use the uncounseled tribal court conviction as an element of his own offense to say, hey, because he pled there, he's guilty here. And so that's why they held that out, and they did a good job of distinguishing it. Cavanaugh followed the rationale of the Cavanaugh case, but now I heard that there is one percolating in Montana that could put us at odds when we have 2 conflicting opinions in the circuits.
Thank you so much for coming, and I'd like everybody to join me in thanking her and for getting us back on track too. This is great. Thanks so much.